case briefs, and so much more. LSData's got what you're looking for.
A legal showdown between Frank Diehl Farms and the Secretary of Labor took center stage in 1983, with the United States Court of Appeals for the 11th Circuit serving as the battlefield. At its core, the dispute was steeped in two contentious issues: the scope of the Occupational Safety and Health Act, OSHA, to regulate employer-provided housing, and the extent of compensation for injuries suffered by employees residing in such accommodations. Diving into the case specifics, the lower court ruled that the temporary housing voluntarily offered by the farmers in Hillsborough County, Florida, fell under the purview of the workplace. Consequently, it was subject to OSHA regulations. The farmers challenged this verdict, maintaining that OSHA's jurisdiction was limited to accommodations where living on site was a prerequisite for employment, not a choice. Upon review, the case landed in the 11th Circuit Court, with the Secretary of Labor lobbying for deference to the Occupational Safety and Health Review Commission's, OSHRC, interpretation of workplace. Their assertion was firmly rejected by the court. Instead, the court underscored that it held the final authority on legislative interpretation, and while respect could be given to an agency's interpretation, it was not binding. In a decisive twist, the court ruled in favor of the petitioners, arguing that the condition of employment standard was Congress's concern for employee safety, not the voluntarily provided housing. It concluded that the lower court had erred in validating OSHA citations against the farmers' migrant housing because the dwellings did not represent a work requirement, and therefore fell outside OSHA's authority. Bringing the compensation issue to the fore, the court used state law as the yardstick. It established that a stronger causal connection between employment and injury needed to be present for compensation to be applied. In the absence of a reasonable alternative to housing options, such accommodations should be deemed mandatory. In conclusion, the court ruled that injuries sustained in optional housing were generally not compensable by the Act, with the citation checks by OSHA on the farm duly reversed.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.